Well, good evening, everyone. We're going to be talking tonight about whether or not you should hire that attorney in your family law case. We did a webinar on this a long time ago, way back when, and we wrote up a white paper on things that you should ask an attorney. We have some additional things to add to update you and make it simpler for you to figure out whether or not that attorney should qualify for you to hire them for your case. So if you're here with me tonight and you have an attorney or you don't, if you're trying to find another one or you're trying to find your first one, you need to watch this. I'm Sherry Palmer with Fixed Family Courts. It's www.fixedfamilycourts.com. And tonight we're going to talk to you about a brand new blog that came out from another attorney admitting that attorneys are failing to provide protection to parents for parental rights. No surprise to most of you, most likely. But let's talk about what he discovered so that you can actually use a test to determine whether or not your attorney should qualify to be on your case. Sound good? All right. So first we're going to start off with a quote from this attorney's blog, where he says, after losing case after case, he simply gave up. Like the dogs in the study, he had learned there was little he could do to change the outcome of the case. So why bother fighting? Makes sense, right? If you keep losing, why would you keep fighting? So finding an attorney who's going to protect parental rights can almost be impossible. We get those complaints every day from all the states. I can't find a lawyer. Can you refer us to a lawyer? So I'm going to tell you why we don't generally refer people to lawyers. It's because they aren't going to give you the protections that are required according to what we've learned and what we teach is necessary to protect your child and to protect you. Now, that doesn't mean parents don't find attorneys who they then can give this information to, who then use the information. This is true. They do that. And we're going to talk to you about what happens with that and outline it for you so you can see the steps and the challenges that you're going to be faced with that you have to overcome. So that's the most important thing, is knowing which attorney to hire and how to overcome the challenges, right? So this attorney that I'm talking about is an appellate attorney who wrote this blog on the 11th, and his name is attorney Vivek Sankaran. He does not represent parents in parent versus parent custody suits, but what he does do is appellate cases for CPS suits where the state is trying to remove the children from both of the parents. What he also does do is he trains attorneys how to conduct their trial so that they create a record that he can use on appeal. And what we do is we teach you and we train attorneys in cases between parent versus parent on how to do the exact same thing. How to protect the record during your trial court, how to develop it so that if you run into the situation where you need to appeal, you actually have put into the record what's necessary to make those arguments in the appeal. And if you guys want to comment, hi Tobias, I see your comment. You haven't found anyone that will stand up for your rights of yours. We're going to talk about why that is. Okay, so thanks so much for joining me. Stick with us here so you can learn this. It's very valuable. This is like one of the most basic things. We've been teaching it for a little while, but we didn't actually label it, and now we have a label for it. So if you've ever discovered particular labels in your case that helped you focus on the right solutions, this is one of those videos. If you ever suffered parental alienation and didn't know what it was, and once you learned the label, you were able to find the body of knowledge and information on um, how to address that challenge. This is the same thing. Okay, so and we agree, you guys, with this attorney, Vivek, that a little outrage is necessary here because what is the primary job for an attorney? It is to advocate for you. Instead, they end up advocating for your child. They end up collaborating with your court and the other side. You end up feeling like you're just paying somebody to become buddies with everybody else or who was already buddies. So we're going to help you avoid that. What this attorney discovered is that attorneys are acquiescing and they're not advocating for your clients. So when you go to actually like look to see if you have an argument for appeal, you don't find the proper words in the record, right? In other words, systems don't automatically bend towards justice. You have to do something. Okay? And one of the things that he says that's key, the key two words that Attorney Sankrin, that's the same one Vivek Sankrin, looks for in the trial court record is I object. But there's more to it than just that, and he doesn't really go into that, which is why we're going into it tonight. We've discovered the same thing happens with you guys. Parents versus parents, same thing happens. You get an attorney, they don't object. You're sitting there wondering, why are you letting this happen? But what's most important to object to, it's not always just the other things the other side is saying. It's objecting to the judge's orders. It's objecting to judges' presumptions and behaviors and all those things that eventually you end up feeling like you need to file a complaint about, or you start seeing their bias, or you start seeing there's a conflict of interest. All those things that you're feeling are the things that you need to be protecting yourself from so you can challenge later, and that's not happening. Those are the things you object to. And we're going to get to the steps for that because there's more to this than just objecting. That's just one of the steps in this. So we personally know constitutional attorneys who have actually given up, right? We know that for parents, giving up is not an option. These are your children. These are your babies. This is the most personal, intimate kind of case you'll ever go through. It is the most important fight in your life for most of you that you've ever been through. It's the hardest fight. So giving up is not an option. So hearing that these attorneys are just giving in and giving up can be pretty devastating. Parents who do give up and leave in despair, by the way, are more likely to expire early, die, and more studies are actually confirming that there's increased risk of leaving a system like this in place without challenge that increases your daily stress and causes mental health injuries is so damaging that it is affecting society in ways that is contributing to early deaths, mental health damage, physical injuries. So this is super important what you guys are doing. To challenge a system like this is necessary to protect all of these things. It's necessary to protect your assets, your dreams. So let's go on. I'm going to tell you some studies that just came out that support these ideas now. So you have studies that support equal parenting, but did you have studies to support that a damaging system like this is actually causing mental health and physical health damage? Well, recent studies just came out from Blue Cross Blue Shield. They published a report that says American millennials, and who are the newer parents, right? It's millennials, they're college age adults. They're just starting to become parents. We know several of them. American millennials are seeing their physical and mental health decline at faster rates than Gen Xers did. they're actually at risk of a 40% uptick in dying earlier than Gen Xers. That's pretty scary. So their mortality rate is worse. So regardless of age, though, parents subjected to this adversarial child custody suits are at greater risk of experiencing what the Blue Shield report found and called deaths of despair. How many of you have felt despair? You know what I'm talking about. Your physical health declines, your mental health declines because you end up in depression. So we're not saying you're crazy. We're saying that it's affecting your mental health. It's driving you into depression. As you resign yourself to the idea that it's hopeless to fight because you're told nothing's going to succeed anyways, it's not going to matter what you do. Hold on real quick. My power is saying that it's not functioning. Maybe not. Hold on, guys. I'm going to lose power here, so I'm not plugged in. Can you? Okay, so we'll get that resolved. So you're being told you're not going to succeed no matter what. So if you resign yourself to that despair, the statistics aren't real good. So you don't want to do that. What are some of these traits, and what's going on here? What we're talking about that's happening to the attorneys, yeah, and to you is called learned helplessness. I'm trying to turn my head so that I'm not glaring in your faces. If you've ever heard of learned helplessness, great. But if you haven't, let me explain to you what it is. Learned helplessness is based off of a study by Martin Seligman. And that study was where he studied dogs and in relation to shocks. He would shock the dogs, and he discovered that once the dogs decided that they couldn't escape the shocks, they stopped trying to escape the shocks. Another example of learned helplessness would be the rat experiment, where, let me take these off, where rats were put in a bucket of water. You might have heard of this. And when they thought they were going to be saved, they would continue to swim. And how did they think they were going to be saved? They would see the other rats being scooped up out of the water. When enough time passed where they didn't see a rat scooped out of the water anymore, and they gave up hope, they stopped swimming. So a lot of times we call this, you just become hopeless, but this is actually called learned helplessness. So look up Martin Seligman's work and you'll see. So what are some of these traits of learned helplessness? It's passivity. What do you get from these judges? What do they expect of you in the courts? When you're in court, they're like, oh, don't speak up, just be quiet, just take it, we'll change it later. Giving up, procrastination, decreased problem-solving abilities. You get under enough stress, can't think very well anymore. They keep you in the dark, so you don't know what decisions to make. You start having memory issues. You stop trusting yourself. Frustration and low self-esteem. So even if you went into this with high self-esteem, could you be at risk of that self-esteem lowering? Absolutely. Especially when you've been able to succeed at everything else in life, and you get into this situation and you can't even protect your children from the harms that you see occurring and being administered and demanded on them in this process. So these symptoms lead to increased stress, anxiety, and, you guessed it, post-traumatic stress disorder, PTSD. If that sounds familiar to you, now you have an answer to what is going on and why these things are happening and continue to happen and why they're not getting resolved, right? Because you're hitting something, you're hitting a challenge that you didn't know what it was, And instead, you would put more pressure on the attorneys and demand and say, hey, I want you to do this, I want you to do this, without addressing the fact that attorneys are human. They suffer from these human conditions. These are innate biological responses to shut down when you're not having success at things. So you're going to be the person now to help them break through that so that they can serve you better, right? And the way that you do that is by saying that you recognize what it is they're going through, you recognize the challenges they're going to face, and you're going to give them solutions on how to address those challenges. That's why we provide you guys with the motions and the samples in this training, because you are helping them out of that learned helplessness, and you need to tell them that not winning, as long as they are promoting the right arguments and progressing this movement properly, not winning is not the bar right now. That's not the measure. And hang on, Ron has some input.
Yeah, I just want to say that this learned helplessness can be overcome, and you can learn not to have it affect you nearly as badly. Our military trains people to deal with stress. That's what basic training and boot camp is all about for most services, especially Marine Corps, especially Marine Corps Infantry, which I served in. Right, I went through this incredibly intense training where you are constantly under unrelenting stress for 13 weeks, and it trains you to overcome that stress and to operate under that stress. So it's possible to operate without it, and that's one of the ways I'm able to do this work, because Sherry and I both suffer from this in this work, because it's brutal to deal with this constant beatdown by these courts that are criminal. But
and how do you think it feels for each parent to come and go, oh, attorney won't use it, attorney won't use it, and them come and say, can you represent me? And we're like, no, we're not attorneys. We're so sorry. We don't practice law. We can't substitute attorneys. It's very frustrating for us, too. That gets us down.
Right, that's one of the reasons you'll see that I don't add people on Facebook, because I have to have some area where I don't have that stress, right? Everybody has to find a way to deal with it. And if you're going to fight this, you've got to focus on your mental health. And then you got to make sure your attorney is capable, which is what Sherry's talking about.
Right. So what is learned helplessness? We said it's learned, it's a learned cycle and learned behaviors of giving in, conceding to the status quo, right? Not challenging the system, not challenging those in authority, not challenging those who start to get promoted as the prevailing party. Okay, and it was discovered by Martin Seligman in the 1960s when he was studying the causes of depression. So more and more adversarial litigants are opting to do what? Become pro se. Most of you didn't go into this saying, hey, I want to be a lawyer, I want to learn this. You're being forced into it because you cannot find somebody to protect these super important rights that are necessary to be able to continue to not only control choices in your life, but also to protect your child. Self-representation has become necessary for parents, not only to protect, like I said, your future ability to control your own destiny, but also to control your own mental health and your own physical health, right? It's that important. So I'm so glad you guys are here and sticking with me. If you're experiencing any of this, by the way, let me know and post a comment here, because we do have several people that we work with who specialize in these areas that can help boost your ability to process this information. And we'll put links to them in the blog so that you can get some of that additional assistance. Attorneys who do advocate for parents wanting to challenge the application of, and these are things that we do with our motions, best interest doctrine, who want the judge challenged, and who want to demand that the judge apply all the doctrines required so that justice may be done, are being challenged with threats of sanctions, held to higher filing standards. They're getting picked on. They're being reprimanded in private and treated as if a request to apply the Constitution is an insult to the judge, right? How many of you experienced that? You had an attorney, you got them to start fighting for you, and all of a sudden they withdraw. Or they tell you they can't do it anymore. Have you had that happen? Type yes or no, so I know what you guys are going through, so I know that I'm tackling the things that are important to you. So parents involved in CPS suits in small towns often find their attorneys have relationships with DAs, representatives, and CPS workers, right? So we're not just talking about the parents in the two parent suit, parent versus parent. This is happening to people who are hiring attorneys to protect them from the state coming in with their third party agencies as well. We see attorneys becoming nothing more than paper pushers and used in collaboration with approving service plans, getting parents to sign consent in order to avoid the effort it takes to advocate for you instead, right? They're just wanting you to give in because then they don't actually have to deal with the fact that they have to put effort into the challenge, right? They can avoid all of this mess, this negative pressure that gets put on them when they try to help you. So let's get to protecting the record. This is how you're going to help yourself and help your attorney. We said earlier objecting is not enough, right? And I'm so sorry about the reflection in my glasses. So I'm like trying to look different ways so you can see me better. Objecting is not enough. It is part of the process for preserving error, but it's far from all that is necessary to develop the court record for arguing on appeal. So, what are some of the things you need? I'm going to give you a few of them. One is you must keep that objection preserved. Two is you must know what kind of objection to make. Okay, so I'm going to give you the several of them, then we'll go over it a little bit. Three is you must get rulings on your objections. Hey, Clutch, thank you so much. And I do see you guys there. And Kendra, hey, Kendra, great to see you here. And that's just a start. Let's just go over three to keep it simple. Okay, so the first one, you must keep that objection preserved. How do you do that? Well, first of all, you might object in your motions to them using, let's say, best interest statutes to violate or to restrict or to take away some of your rights and your time. So you're challenging best interest doctrine. You may not even be challenging a specific statute because it's intertwined throughout the whole code, right? So you're challenging the application of the doctrine. So you object in your motions. But then how do you preserve that objection as your case proceeds? Well, every hearing you go to where you know they're using that standard as a basis, you have to renew that objection. And now let's fast forward to your final trial. In your final trial, you may need to object multiple times in multiple places. And this is where attorneys mess up, even ones who file these arguments for you in these motions, is they just do one objection and they're like, okay, I'm good, right? I did it, giving you what you want, and then they just proceed through the trial like they normally would. And you're thinking, I'm protected, put it on the record, just like Ron and Sherry said to get my attorney to do. They did it. Well, and then you're disappointed when you go to challenge it later. So, what do they need to do? Well, when the judge makes their order, they need to object again. They need to also find out whether or not, and they probably know this, but maybe you don't, and so you need to find out, because if you don't see your attorney doing it, then you need to nudge them, okay? You need to write it down. You need to prepare them in advance and say, hey, I want this to happen in my representation. Yes, I want you to use your legal technical skill. However, if you're not willing to do this for me, then you're not the right attorney for me. And we're going to get back to that about finding the right attorney. Okay. So you're going to look up and see, are there running objection requirements? A running objection, or Is a running objection available, not requirements? Is it available? The reason I ask for that is because you'll find some judges get annoyed when your attorney is objecting a lot or you're objecting a lot, right? They feel like you're not letting the case develop on the record and they want to hear everything. Of course, it's your case. You get to decide what gets heard and what doesn't get heard. At least that's what you're supposed to be able to decide. So a little annoyance from a judge doesn't mean don't do it, but I'm just telling you this is why a lot of attorneys don't. Remember, they stop doing things because they respond to that negative result that they got. They didn't get a positive result, they didn't get that reward, so they stop doing it. Okay, so if a running objection is available in your state, ask them to use it and be very specific when you state on the record what it is that judge or that attorney or you are objecting to. Okay? Very specific. And a running objection means you don't have to object throughout the entire trial on that one issue. So if there are other things that you're addressing, like jurisdiction, there's those arguments in our motions. If you're addressing whether or not if you're objecting to the court applying prior restraints on violating your First Amendment rights to association, every single one needs to have an objection on the record that needs to continually be preserved. That's what developing the record is. Okay? So if there is no running objection, what can you do? If there's no running objection, you've got to object every single time. And if that judge, my mic, okay, is that better? I hope that's better, you guys. I accidentally had, thanks Kendra so much, my sound person. Oh gosh, I hope this whole thing wasn't horrible. Okay, so hopefully it just started happening. Thank you so much, you guys. I'm so sorry. So many of technical things that get me hung up with. But I've put a lot of this in writing too, and I'm going to post it on my blog as soon as we're done here. I'll put the video there and the blog. Okay, so if you do not have a running objection, then you are going to have to object every time. So maybe your attorney needs to say, hey judge, the state doesn't have a running objection. I'm sorry, I have to do this to develop the record for my client. We are asking for these protections. The court doesn't normally provide them, so we're left with no choice. This is the way that I must, as an attorney hired by my parent, customer, client, I must advocate this way. This is my job. Okay, so what's the second step? Now you've preserved that objection throughout the right. Oh, you have to know what kind of objection to make, right? So you can't just say, I object all the way through the trial. Then the judge is going to tell you, shut up. They're going to deny you and they're going to tell you, stop it. I don't want to hear your objections anymore. This is where the judges get frustrated to the point where now they can shut you down because you are not providing the right legal words. You're not protecting the record properly, so they get annoyed and irritated, frustrated. You have to know what kind. So some of you have heard hearsay. There are hearsay objections, right? Some of you have heard objection, no predicate. So there's lots of different objections that can be made. Objection violates objection, we're objecting to the jurisdiction. Objection, we're objecting to the application of best interest. So you can be specific like that, okay? Just as long as on the record it shows, because remember, if the appellate court looks at it, they don't get to be there in person, so they don't get to ask you those questions. And not all appeals have oral arguments, and you only get 20 minutes in those. So you have to you have to develop the record like it's a story. It's your story. It is your story, by the way. And the only way they know exactly what you are addressing is if you state it. So just remember that. Say, how will they know
what I'm objecting to if I don't give the specifics about it. Okay. Third is you must get rulings on your objections, right? This is the tricky one, right? Because so many of you are just like, whew, okay, we objected, let's move on. Let's hope the judge doesn't get irritated, and you don't want to push. Well, you do want to push, actually, because there are some appellate courts that will say, judge didn't rule on it, you didn't push for the ruling, you waived it. It's happened in things like arbitration. Some people's orders show that they get arbitration instead of having to go through these expensive jury trials, and then when it gets ignored and they end up going through the trial, they try to appeal that, and the appellate court could say, sorry, you had to have the judge actually deny it, rule on it, before we can say that you were denied. So those are some of the reasons we've actually learned from this in appeals with parents trying to appeal specific things. So that's just a start, right? What other training is available? We have a signature course to help you prepare during your trial to protect your rights to appeal. We are producing a new course. We do have our courses that we've had in there. That's our foundational courses that does teach you the foundation of these arguments, but we're also developing some more step-by-step courses, and we have a signature course coming out on appeal. I protect your right to appeal. So just as Sankarin is training the CPS attorneys, we're training you. You're training your attorneys. We're training your attorneys. We teach you from our experiences what you can do to teach your attorney how to protect your case for appeal. So I'm going to look now what questions you have, because that's pretty much what I wanted to tell you here. Oh, and before we get to that, we want to go over the test. What do you do to decide whether or not you have the right attorney before you pay them? You need to apply the Learned Helplessness test, right? You need to figure out, is this attorney suffering from learned helplessness? So how do you do that? Simple. You just ask them, what is their plan for protecting your parental rights? And if they respond with, you don't have any, guess what you do? That's when you let the door close behind you, keep your money in your pocket, and go on to the next one. So what if they get past that first one? Like, let's say they're good at bluffing you, and they say, okay, yeah, I'm going to protect your parental rights. And you say, what do you believe my parental rights are? And they might say, it's whatever the judge decides they are. Guess what you do? You leave. It's as simple as that. So what's the third thing? Okay, let's say they get past that and they go, yes, I do believe that you have parental rights. But those rights don't apply to you because the other party in the case is the other parent, and they neutralize. Hold on, don't go out the door yet. This is your opportunity with this one to say, are you open to hear some persuasive information? Don't call it argument, because if you're going to argue with your attorney, they're going to say, what the heck are you here for? You don't need me to argue for you. You can do it yourself, right? Why do you need me? You say, yes, I understand you are the expert in the legal aspects of the law. However, I believe that the law is being applied improperly to parents, and that attorneys are suffering from learned helplessness. And if you're telling me that my rights neutralize themselves, and I can show you that that's an incorrect application of my rights, and that's what's preventing me from getting the protection of my rights, will you consider applying these arguments? And if they say yes, great. Then go on to the next question. The next question is, how will you protect these arguments throughout the case, the development of the case? And if they say, okay, well, I'm going to file them like you're asking, you say, then when you go to the hearings, will you object every time the judge tries to demand an order of me? Will you object when they try to appoint a guardian ad litem and an amicus? Will you object when they try to conduct exploratory searches? Guardian ad litems and amicus are exploratory searches. But will you object when they try to impose child support on me, and when you make this argument regarding child support? And you go down the line with the arguments that we made in the motions to get that confirmation. So don't just get a general, yes, I will help you, I will use this, because we've seen parents hire attorneys who have said that. We've even seen attorneys file the motions and then bail. And what just happened? They spent a retainer on them. Most of the time they've replenished that retainer once, maybe twice, maybe 3 times. Those retainers can be like, they can be as low as $1,500. They can be high as $10,000 or more. So you could have very easily, let's say on the lowest end, could have very easily already have spent $3,000 or $4,500 or even $10,000 or $20,000 before you realize that this attorney is not the right attorney and that they're suffering from learned helplessness, right? So this is what you're looking for. Are they suffering from this already? And if they are, and you can't persuade them, you can't help them, you can't lift them out of that cycle, don't spend your money on them. You're not going to get these protections. You are not going to get these results. You're not going to achieve what you set out to achieve, which is to remain in control of your life. I hope that's what you're trying to achieve, and not trying to take over control of the other parent or be in charge of their life or control everything they do with your child, because if you are, you're in the wrong place here. You're in the right place if you're just trying to protect yourself from the government overextending their parens patriae authority into your life, right? And you're trying to protect your child's ability to be with you in the least restrictive ways, which ultimately ends up being equal until other things are proven, right? And if you're in our course and in our membership at fixedfamilycourts.com/membership, you will be able to answer what those are. If you know what some of them are, go ahead and post them in the comments. Let these parents know that you are learning. Let attorneys know what these are, because some of them don't have the benefit of being in there. So they need to see some of these to encourage them to get in there. So if they don't have the benefit and they are absolutely homeless and they need some assistance, some of those parents have reached out to us and we try to help them out as much as we can. But it really relies on you guys who have at least some basic minimum resources to move these arguments forward, because somebody who's completely broke really isn't gonna have the resource to do this. Yes, there have been people in jail who, you know, have gotten rights protected and advanced forward. Those are the exceptions, not the rule. And of course, they have their basic minimums being taken care of. They're being fed and they have a roof over their head. So if somebody's homeless, they may not have that. So it's very, very difficult for them to get it. So even more important for you guys to fight, so that you can help protect those who can't. And thank you so much for being here. So let me see. What'd you say, Tobias? Chief Justice John Marshall never said that if it's unconstitutional, you have to appeal his decision.
What?
I don't know what that is.
What's he talking about?
So Tobias, you're saying you tell them you don't have to do crap if it's unconstitutional.
That's not true.
Yeah, unfortunately, they can enforce unconstitutional orders. So while there are some parents that do violate orders that are unconstitutional, like gag orders and things like that, sometimes they go to jail, sometimes they don't. You eventually can prevail on those, but again, you got to know what you're doing, because if you don't, they can still trick you, they can still enforce bad orders. So you have to have somebody good arguing and fighting for you. So someone said they haven't found an attorney yet that will stand up for any rights of yours. Well, hopefully this has helped you
Look for civil rights attorneys.
To find someone. And Ron says, look for civil rights attorneys. Yes, some of them have stopped advocating for parent versus parent cases because of this learned helplessness, but approach them with these ideas and say, hey, do you think this could be happening? Are you willing to fight again? Because if you tell them that you know that this is a fight, you know that there are high probabilities that you're going to be denied and that you're going to have to keep fighting and teaching other parents how to fight, maybe then they won't get so down once they realize you understand the process and what's happening.
And that's one of the places where you may want to use our services, right? We have very good luck when talking to attorneys who are truly and openly willing to do this, to help them, guide them into understanding how it can be done and giving them the supporting case law to do it. So if you find an attorney and you're asking that question, you think they're open to it, but you want to clarify, and maybe they're not certain on how to do it. It may be that they're willing to do it if they understood the arguments. That's when you would want to schedule some time with us. We would talk to the attorney, walk them through an overview of the arguments, get them comfortable that they can successfully do this.
Yeah, because if they don't understand it and they don't think you understand it, then they don't think that they can protect this argument. They're not going to do it. So Gary, you said, are we nuts? They all work for the courts. And you said you should read the one-parent friendly doctrine. Okay, well, first of all, the one-parent doctrine was overturned if you're talking about the one in Michigan State. And, you know, really, they have a semblance of that in all kinds of states. But by the way, you can challenge it as well. So a parent in prison got the one-parent doctrine ruled unconstitutional and overturned in the state of Michigan. Look at the case N. Ray Sanders. We've been teaching that since that ruling came out. We've been teaching at least since 2014. We have a webinar on that as well. Okay, Tobias says he's telling them they have no right unless they adjudicate him. That's a good start, Tobias, but you also have to learn to develop the arguments a little further because they are going to challenge you on it. So you have to know how to overcome those challenges. And that's what the difference is. Like with the people who get our book only, not in the child's best interest, which you can get at our website and on Amazon, they when they progress through their case, most of them get into the membership site because they find that they need to go a little deeper into the material and into the arguments. We only had so much space in the book, and we have since progressed many of the arguments. We still use that as good solid foundation. We use it, but we have additional information on it, and we have developed more areas and some of the areas much deeper.
As an example from the book, we talk about the rights should be protected at strict scrutiny, but we don't prove it. We have since proven that the rights must be protected at strict scrutiny, and we have a significant amount of case law proving that, which you'll find in our membership site and one-on-one coaching. You won't find it in the book. It just takes too much time to update the books and too many resources.
Yeah, so we've chosen to update it electronically in the membership site piece by piece. We have concept courses, we have signature courses, master courses that are in development. And when you're members, you actually get to participate with us throughout the development of these courses. So you're getting the benefit of the information and our experience immediately and not having to wait for a fully polished up, packaged entire course, right? You're actually getting to go through the lessons and topics as we put them into that membership site. Let's see if you guys have any more questions. Tobias, cute. He wears red, white, and blue to the court. Absolutely. Have pride, have confidence. You know, that does a ton for your mental health and for your stress level, right? So if you walk into the court head down, feeling nervous and scared, I just talked about this on my live yesterday, that can get interpreted actually to hurt you as deceptive, manipulative, like you're not being honest, because those are traits that our brain naturally processes and interprets as deception, lying, you know, those types of things, manipulation. So you don't want to be nervous. And if it helps you to go in there showing that you are a citizen with pride, just don't be cocky, Tobias, okay? Yes, my mom and I do come off that way in court, but I can tell you, men, unfortunately, there are gender differences in courts, and men tend to be more feared in the courts. You'll see judges calling their bailiffs up and standing closer to you, approaching you, because they will assign aggression to you. So you may be just showing confidence and pride, and they might take it as a threat. So make sure you're not coming across as a threat. It is their courtroom. They do have awesome power in that courtroom. So you have to Tobias, you're not just asking for running objections. There's a lot of other steps in this, but it would take a long time. I try to address just one piece of things each live so that you guys can digest it. If you want more, come to our webinars and our workshops, and we progress you through the course materials there. But I just introduced you to a little bit each one so that you can digest that, work through it, go into our site, read more on it, read our blogs, and then ask more questions. So as you're learning, you're going to develop more questions about how this works, right? And then imagine applying it, right? Practice applying it. Say it in the mirror. Say it to your friends. Have them respond back, because they're going to probably have similar responses that attorneys would have, because like I said, they're human. So if you say something that sounds absurd, they're going to respond like it's absurd, and you can refine certain things like that. So that might be a good suggestion, to just practice it as if it's a script or a role that you're going to play. It is your story. Practice it like that. Daniel. Hi, Daniel. How are you? Let me see what you're saying. Correct me if I'm wrong, but we can get an attorney to agree to these things. He still had a contract that states nothing is a guarantee. So what protection do we really have? He can essentially lie to us. Well, Daniel.
No.
So Ron's going to respond to this in a minute, but what I'm going to tell you is that's why you walk through these questions that I gave you earlier, each one step by step, so that you get that agreement specifically, right? And then Ron has a comment.
Okay, so that statement you cited that the attorneys will put in there is not a statement about their delivering what they told you they would deliver. That is a statement of the fact that the judge ultimately decides, and the judge can decide erroneously, and quite often they do decide erroneously. Even if your attorney does everything perfectly and proves everything beyond even a reasonable doubt, the judge can still rule erroneously. That's why that statement's in there. It does not mean that your attorney can promise you something and then fail to deliver that,
Right.
because then you would have an argument, ineffective assistance of counsel, and you can actually get your orders overturned based on the fact that your counsel failed to do what you had agreed to do and protect your constitutional rights. Now, good luck finding an attorney who will sue another attorney, but that's how it can be done and has been done.
And get these in writing. If an attorney's not going to sign off in writing, not that they guarantee that it will work for you, but get in writing that they are guaranteeing that they are going to advocate for your parental rights in these specific ways. This way, too, they'll raise objections with you that you can address or bring us in to help you address, so that they don't have those resignations. Because if they're unclear, how do you expect them to argue it when they end up under pressure in front of the judge? They've got to respond like that.
So keep in mind, attorneys have a special duty to you, because it's called a fiduciary duty. It's a legal duty to protect your rights and to protect your interest. Now, you tell them what your interests are, they are duty bound by law to protect those interests, and they can't do anything else. That's why they get special compensation for things. That's why your conversations with them are protected and other things. One of the things you'll find in family law, something we've talked about before and we should probably talk about again, is that your attorney will often think it's their job to decide what's best for your children and do that instead of acting in your best interest. I've actually argued with attorneys online on this topic where they bragged about doing what was in the best interest of the child, and when I raised the issue, well, then you just violated your fiduciary duty to your client, they disappear.
Which is
they
you.
run and hide
Which
because
is
they know
you.
it's illegal. They can be sued for it.
It's you. You're their client, not your child. It's your job to protect your child and decide what protects that child. That's where they mess up. So Ron argues that
Make sure you get that clear with them.
Yeah.
Right? And clear at the level of fiduciary duty. Don't go throwing that term around because you'll scare them off. But subtly make it clear that you know they have a duty to protect your interest, not your child's interest, and you want to know that they're going to do that.
Yeah.
Without threatening them. Don't threaten them. That's pointless.
Yeah. So Clutch 911, you say, I have my first child support hearing next week. What tips can you tell me to help me stand up for myself and my constitutional rights as a man? Well, this one's not on child support, Clutch. We do have an entire workshop on the entire webinar, actually. It's not the workshop. because we have a brand new child support motion. And when I say motion, these are samples, and we did them this way so that it reflects what attorneys are used to seeing, so they understand how we're proposing the arguments be used. Okay, then they use their legal technical background to use them. But for the child support, if you are facing enforcement clutch, is that what you're facing? Then you'll want to get that go into that workshop. If you have a membership, you can do the workshop or webinar. Sorry. You can do it for free in the membership, and you can get that child support motion in that membership. If not, you can actually purchase those arguments on our website, fixedfamilycourts.com, under products. And it's actually less for you to go into the membership because you get more training, there's more materials for you to wrap your head around that argument, because you don't want to just learn one piece of the argument. Let me warn you guys now, you learn one piece and they're gonna wiggle around you in another area, and you will have no information up here to resource from when you're being pressured. But here's the great part about this membership: it is accessible through the internet. So if you get permission when you go to court to keep your phone on and have access in that membership site, you can search our books. There's 3 books in there digitally for concepts. Also, if you know where something is, you know it's under a concept or under one of the topics, or in one of the courses that we're teaching, what you want to do is note down where it is, whether it be up here or on a tablet you take with you, so you can access that to get more specific from that information during the time that you're in that courtroom. As long as you got permission to use your phone, tell them it's your research and your resource, right? You don't have to tell them what you're looking up on there. You just tell them that's where your notes are, and that's what you're using it for. Hey, that actually worked better when I closed my computer screen. Let me try that again. Nope, not really. Okay, so let me see if there's any other questions. If not, let's see. Clutch, you said, also, if I'm not on the birth certificate, so they are going to first ask for a DNA test, I guess. Yes, Clutch. They are going to want paternity proof, so you have to establish paternity. What's your...
Well, you're there according to the specific rules in your state, not necessarily a DNA test. So you need to figure out what is required to establish a
Well, he's not on the birth certificate.
Well, that's
Were you married to them? If you're married to them, you're presumptive parent in a lot of states. So
right.
Look up your statutes first. Make sure you're following exactly what they require, because what I really get disappointed with, and this child deserves to have you in their life, is when somebody doesn't follow what's required in the statute and loses their rights to their child.
Part of it constitutionally is whether you have an established parent-child relationship. Right, so if you're seeing the child, if you're taking care of the child, if you're supporting the child financially, that's grounds to assert paternity as well. There are lots of different grounds, and there's different rules in different states. So make sure you find out what those are. Don't give up and do what the statute requires. But that's something that's very technical. You need an attorney to make sure you're doing just the right things. Mm-hmm. But once you have established paternity, you have a right to then seek to establish the parent-child relationship, and once you establish the parent-child relationship, then you have constitutional protections for that relationship.
Yeah, and Kendra made a good point. She went through 2 attorneys, and 2 terrible ones, she said, while she was restoring her strength and confidence, and all they did was make things worse and create brand new issues. And she said now she's her own hero that has to come in and fix the issue. So she's stepping up to the plate, taking responsibility for what is presented, and you need information and you need training to do that, and that's what Kendra's doing. So Kendra, we applaud you. Thank you so much for giving us the privilege to serve you, teach you, and help all of us progress these arguments, because if it's not like if there weren't parents like you, where would we be? We need people like all of you to progress these arguments, right? And so you have to be willing to take a little beating. You've got to be willing to take responsibility for these arguments. So you are turning your pain into power for yourself, for you to learn to be effective, right? And so that means if you think you can't do it, find out what you need to do it, instead of just saying I can't and then curling up and getting depressed in the corner. Say what's out there for me, so that you're basically persuading yourself what's out there for me so that I have a way to do this, right? Where there's a will, there's a way. So let me see what else is here. Okay, clutch, not married. So then again, go back to your statutes in your state. We're talking about paternity there. Go back to your statutes in your state and make sure that you follow and you satisfy what those statutes say is required. And don't forget to also incorporate the Constitution. And that's the part where you learn from us, because they don't put that in their statutes. And they don't give you that information when you hire them. And that is what Ron was talking about. If you have an established relationship, and how do you establish it? Maybe you've been supporting that child through finances. You have to show that you have an established relationship. It doesn't mean you got to see the child every day, right? That may mean that you claim the child as your own, that you've been representing that that's your child. There's lots of different ways to do it. You just have to learn what those are and have those ready as your responses, right? Your responses have got to be timely, and they've got to be appropriate, and those are the things that you're learning here. So, okay, let's see. Great. Sounds like you're on the right track, Clutch. Okay, so I think we got everyone's questions. Anybody who jumped on here, let's do a quick recap. Tonight was about learned helplessness. This is something attorneys are suffering from. So before you hire them, you need to find out whether or not that attorney suffers from this condition. If they suffer from this condition, they are not going to protect your parental rights. Your parental rights are the only thing that protect you from government overreach. And protect you from the judge playing super parent. Protect you from being forced into the demands of the other parent. So what is going to protect you? First of all, finding the right attorney who's not suffering from the condition of learned helplessness. What else is going to protect you? Learning what questions to ask so that you know what tests to give that attorney before you hire them, so that you can decide if they suffer from it, because they may tell you no. Don't buy that. You've got to ask the right questions. Don't just go in there asking them, have you won? Have you done this case before? Are you certified in family law? Those are all Bar Association criteria, and the Bar Association has not been teaching them or encouraging these attorneys to protect your rights. So why would you rely on standards that the Bar Association set that were not put in place to protect you at all? So don't rely on those. Don't ask those simple, basic questions. Don't just go to the ones online that have those check marks next to their name. That just tells you they're trained in the technicalities of the law, right? That the state expects them to apply. The statutes that the state wrote and created. And like we said, the statutes do not incorporate the proper procedures to protect your due process and your substantive rights. And so there's lots of procedural problems. There are lots of due process issues that you learn in our membership site. So the test you learned was the 5 questions. I think it was 4 or 5 questions earlier that I gave you up above. They'll be on the blog site. Also, the other parts of this is learning yourself how to develop the record and how to protect the record. So we went over 3 different types, or 3 steps in developing the record regarding objections. We also said that's not all of the steps. That is not everything that you need to do. Do not take one piece of something, try to apply it, and then turn around and say, oh, didn't work. That's what they want you to do. They want you to look for that silver bullet, that one thing that will make them stop what they're doing. There isn't any such thing. Law is a battle. You are in a war. You are going to have to prepare for each battle. Okay, don't forget that. So I think we went over everything. Thank you everybody for coming, and let me know in the comments if you like it, what else you'd like to see comments about what we covered. I'll answer questions down the road because they pop up. I get notifications when you post comments below. Oh, like on our page, follow us, because some people said they're not being told when we go live. So if you want to be notified, like on it, click on that bell, and like on our Facebook page. I try to get them up in both places, so like on both, because we do lives in both places. All right, thanks so much for coming. Talk to you next time. Bye.